This is Bloomberg Law with June Grasso from Bloomberg Radio.
In one of the most high-profile cases of the term, the Supreme Court divided 6-3 down ideological lines, limited the power of judges to block government policies nationwide. President Trump praised the decision as a monumental victory.
Thanks to this decision, we can now promptly file to proceed with numerous policies that have been wrongly enjoined on a nationwide basis. And some of the cases we're talking about would be ending birthright citizenship, which now comes to the fore.
But the ruling did not address the constitutionality of Trump's ban on automatic birthright citizenship. And the justices returned the 3 cases to the lower courts to consider whether to keep the ban on hold for longer, at least in part of the country and perhaps in the entire country. My guest is constitutional law expert David Super, a professor at Georgetown Law. David, the administration seems to be giving this decision a very broad reading. Tell us what the justices actually ruled here.
It's really a very narrow technical decision. There are some lower court decisions that enjoin the administration's birthright citizenship policy nationwide. And the court says that district courts can only issue injunctions on behalf of parties in front of them. So the injunctions to protect particular plaintiffs can stay. And the court's very clear that if the plaintiffs can certify a class action, that all members of the class can get relief. But they say the district courts cannot issue nationwide injunctions where they are not hearing a case involving people from all over the country.
Justice Amy Coney Barrett wrote the majority opinion and went back in history to reach her conclusion. Tell us about it.
Yeah, what Justice Barrett did was say that district courts don't have statutory authority to issue this sort of injunction. She said that you would have to analyze the Judiciary Act of 1789 when the country was first coming together under the Constitution and find that at that time district courts could issue this kind of order. Her view is that these orders came about only late in the 20th century and therefore have no precedent at the time that the Judiciary Act was being passed.
Barrett wrote that the government's application to partially stay the district court's preliminary injunctions are granted, but only to the extent that the injunctions are broader than necessary to provide complete relief with respect to each plaintiff withstanding to sue. What is she saying there?
She's saying 2 things. One is that for the plaintiffs that are already in the case, that they stay protected. They're not losing anything. And then she is effectively inviting plaintiffs to refile this or amend this into being a class action.
But the Supreme Court in recent years has cut back on class actions, haven't they?
They have, but not likely in a way that would affect this case. The Supreme Court has gotten very skeptical of class actions that involve bringing different plaintiffs together to get damages. The court has also become more skeptical of class actions where there are lots of different facts that have to be proven relating to different people. For example, a class action over racial discrimination might fail because the court would say, oh, discrimination is different for each employee, so we can't do that as a class. But here, there are absolutely no facts that need to be proven. The administration's policy applies to all newborn children and does not require making any determinations about those children and is being challenged on that legal basis. So nothing that the Supreme Court has said makes class certification less likely here. There is a concurrence that says that district courts should not be irresponsible in certifying class actions. Well, who could argue with that? But it doesn't really suggest any concrete basis for objecting to a class action in this case.
I mean, did the majority opinion actually say that the lower courts were wrong to issue injunctions here?
They did, but only to the extent that the district courts protected people who were not parties in the case. In a sense, the Supreme Court is saying that the district courts were sloppy, although they've got lots of company. There were a lot of sloppy district courts in Texas under this standard during the Biden administration who were enjoining, as the court notes, just about every major presidential action.
So Justice Sonia Sotomayor wrote dissent. She said, with the stroke of a pen, the president has made a solemn mockery of our Constitution. Rather than stand firm, the court gives way.
Yeah, Justice Sotomayor believes that the history cited by the majority is incomplete and inconclusive. Justice Sotomayor also makes the pretty compelling point that the whole history of injunctions, of the body of law that includes injunctions called equity, is constant change and constant adaptation to whatever is needed to serve the ends of justice. And that the mechanism or the reasoning that Justice Barrett is using is in itself somewhat ahistorical and is not the way that judges at the time of the nation's founding would have analyzed an equitable question. So Justice Sotomayor meets Justice Barrett on the technicalities, but then Justice Sotomayor's larger point, which prompted the comment that you quote, is that the most serious issue here is that the administration is completely disregarding the 14th Amendment of the Constitution, and the Supreme Court is addressing a small technical matter based on some dubious history rather than facing the open defiance of the Constitution head on.
President Trump held a press conference after this decision came out, calling it a monumental victory.
It's hardly any victory at all. It may help them in some other cases. It won't help them on this one. Their position on this case is hopeless. The court has made very clear that a class action can be filed to enjoin the full implementation of this action. The administration will lose almost exactly as quickly under this decision as they would have under the opposite.
Does this mean we won't see a nationwide injunction issued from this point on?
No, it means that the plaintiffs will have to amend their complaint to allege a nationwide class. There are a few minor technicalities that they'll have to address when they do that, but my guess is that that will happen in a matter of weeks. And once they do that, the district courts will surely find that there is a definable class of people affected by this policy, will grant an injunction for a nationwide class, and the technical issue here will have been surmounted.
What's the next thing that's going to happen here?
The district court will most immediately cut back their orders. Certainly, they won't be covering people in states that are not suing and that are not members of some class of litigants. What exactly they'll do about the states that are suing on their own behalf is a little less clear. The court makes some vague comments about there being problems in that area, but doesn't address it. So I don't know what the courts will do on that. But they will narrow their injunctions initially, but I think plaintiffs will then, within a matter of weeks, amend their complaint to allege nationwide classes, or possibly classes involving groups of states, but my guess is just a nationwide class action. And at that point, the case will go back to being litigated on the merits.
And did the court give any opinion at all on the legality of Trump's ban on automatic birthright citizenship?
Not really, no. They acknowledge that the dissenters regard this order as completely unlawful. They don't comment on that belief as they move forward. So they are staying true to their word and only addressing technical issues here. Many people thought they wouldn't be able to resist getting into the substance. Obviously, they did.
Why is this particular opinion down ideological lines? Why are the liberals on one side and the conservatives on the other on this?
Well, that's a good question because nationwide injunctions were a huge problem for President Biden and a significant problem for President Obama. But I think there really are more internal reasons here. I think that the three liberals are generally believers that the courts have a duty to dispense justice unless the Constitution clearly prevents them from doing so. And this ruling hobbles the lower court's ability to do justice against an administration that has aggressively disregarded statutes and often the Constitution.
Do you think this decision will embolden the Trump administration to issue even broader executive orders?
I really haven't seen any evidence that the administration has been holding back on anything. So I think they will keep on issuing the executive orders that they've been wanting to issue for a long time anyway, and those will have to get litigated on their merits. I hope this will serve as a refresher for people who litigate these cases that they ought to rely on a different form of standing than the one that was found in this case, that they will likely be able to find other precedents that serve them better. But this is going to be a very small blip. Whichever way the court ultimately comes out, this case is likely to be fairly quickly forgotten.
Do you think that this issue will come back to the Supreme Court at some point?
Oh, yes. The administration is determined to pursue its birthright citizenship policy. There's no legal support, so they're going to keep losing in the lower courts on it, and they will ask the Supreme Court to rule. This is an issue, obviously, of great importance to the administration and to the people involved, so the Supreme Court will surely take it.
Yet another case that will bounce back to the Supreme Court. Thanks so much, David. That's Professor David Super of Georgetown Law. Coming up next, the court bolsters the rights of religious parents. I'm June Grasso, and you're listening to Bloomberg. Religious rights once again won out at the Supreme Court on Friday. In a 6-3 decision, the court ruled that public school parents have a right to opt their children out of classroom lessons that intrude on their religious beliefs. In this case, it was about the reading of LGBTQ-themed storybooks. Justice Samuel Alito wrote the majority opinion for the conservatives, and Justice Sonia Sotomayor wrote the dissent for the liberals. It was a matchup you might have predicted after the oral arguments where the two justices basically bickered over one of the books entitled Uncle Bobby's Wedding.
Uncle Bobby gets married to his boyfriend Jamie, and everybody's happy, and everything is, it portrays this. Everyone accepts this, except for the little girl, Chloe, who has reservations about it. But her mother corrects her. No, you shouldn't have any reservations about this. As I said, it has a clear moral message.
Wait a minute. The reservation is about...
Can I finish, please? Yep. It has a clear moral message.
Just answer my question. Is looking at the pictures, is there any affidavit from any parent that merely looking at people getting married, holding hands, none of them are even kissing in any of these books. The most they're doing is holding hands. That mere exposure to that is coercion.
Joining me is an expert in First Amendment law, Professor Caroline Mala Corbin of the University of Miami Law School. Caroline, given the Roberts Court's record on religious rights and LGBTQ rights, was any part of this decision a surprise?
This opinion was not at all a surprise, but it was nonetheless a great disappointment, both for the outcome and for the court's continuing mischaracterization and manipulation of doctrine to get a result that it wants.
Tell us about the conflicting claims from the school district and the religious parents and how Justice Alito came to his conclusions.
On the one hand, you had a school district that has a very diverse population, and they were trying to do what a good public school do, which was not only to have books that represented the people in your community, but also what a school is supposed to do, which is expose children to different kinds of people and to teach them how to all get along, right? That's part of a public school's goal in our country, is to teach our very, very population about each other and how to treat each other with respect, which is the sort of precondition for democracy. On the other hand, you had the religious parents who argued that having their children exposed to ideas that did not conform to their religious beliefs was an attack on their ability to practice the religion, which is a completely novel claim. And although it was a completely novel claim, Justice Alito said, oh, yes, we have always said that this kind of burden on religious exercise triggers strict scrutiny, and therefore this is a severe burden on these religious parents, and therefore the school is now constitutionally obligated to allow them to pull their children out of any lesson that exposes them to ideas that their religion disapproved. So basically, how did he do it? He just claimed that this had always been a law and there was nothing novel in this claim, and they are just recognizing religious liberty in this country as they always had. Now, that's not accurate, but that's how we did it.
The Supreme Court has recognized that parents have an interest in directing their children's religious and educational upbringing, but did Justice Alito take it a step further?
Yes. So parents have always had a right to direct the religious upbringing of their children, and that includes teaching them their religious beliefs and sending them to religious schools. Now, in relation to the public school system, the right to control your child's upbringing, which includes the right to control their religious upbringing, has included the right not to send them to public school. So the parents' right to control their children's religious upbringing means they had the right to pull them out of public school and homeschool them, or pull them out of public school and send them to a private religious schools whose values aligns with their own. That has been the extent of parents' religious rights with regard to public school education. That was it. It did not go beyond that. However, Justice Alito claimed otherwise. He said, actually, we have always said that if public school education imposes this kind of clash with someone's religious values, then the public school has to do something to accommodate them. At least that is how he described a case that did nothing of the sort.
Tell us about that case, the Yoder case, because Alito and Sotomayor disagreed about the interpretation of that case.
So the case he relied on was a case involving the Amish. And the Amish challenged a law that required them to send their children to public school until they turned 16. And the Amish argued this is contrary to our religious beliefs for two reasons. First, it exposes our child to worldly education and values, which we disapprove. And in addition, it's going to undermine the continuing vitality of our Amish culture if we cannot teach them how to be Amish in the community. So they basically wanted to pull them out of public school education and give them sort of Amish vocational education in their community. And the Supreme Court said, fine, we agree it's a violation of your religious rights if you do not have this chance to pull your child out of public school and teach them at home as you see fit. That is the case. So Alito somehow goes from a case where the Supreme Court says the Amish can pull their children out of public school and train them as they see fit elsewhere, to religious people have a right to insist that the public school itself crafts the curriculum that complies with their religious rights. These two things are not the same, and yet Alito keeps insisting that they're exactly the same.
One of the things that Justice Sotomayor was concerned about in her dissent was the chilling effect of this decision.
Imagine you're a cash-strapped school and you were trying to create a curriculum with books of all different kinds of people, and a quarter of the parents now object to a book with an LGBTQ character. And so not only do you have to plan the original lesson with the book with the LGBT character, you also have to plan something for the kids who are going to leave the classroom. And imagine this happens not just with one particular idea that some conservative people disagree with, but a whole panoply of them. It's going to get logistically impossible to be able to accommodate the diversity of objections that parents are going to raise now. And so what's going to happen in reality, unfortunately, is that the school is just going to say, well, you know what? We're just not going to include the books with the LGBT characters. One of her themes was the incredible chilling effect that this decision is going to have. Because now the school, it still has to run. It still has teachers who have to teach everyone. They're already overworked and under-resourced. The simplest path is just going to be, you know what, we're just not going to teach any of these books that the religious conservatives don't like.
I mean, this ruling is just one in a long line of Supreme Court decisions in the past decade that have bolstered religious rights, even when they collide with LGBTQ rights or reproductive rights. Religion always seems to win out with this court.
In the past, I had always felt fairly uncomfortable with predicting the outcome of Supreme Court decisions. But I really feel like for most cases involving these kinds of cultural questions, if you ask, what would conservative Christians want, that is the holding that the Supreme Court is going to deliver. They're going to figure out a way to get the answer that comports with what conservative Christianity would approve. If there's a statute, it doesn't matter what the text says. If it's constitutional law, it doesn't matter what the precedent says. It doesn't matter what the values are. That's the answer you're going to get.
Do you think this opinion will open the door to more complaints like this?
Absolutely. This is not going to be limited to LGBT storybooks about the prince and the knight. Actually, when I was reading it, I thought it sounded adorable. Because the court did not include a limiting principle. The only plausible principle they might have made is that this is fact-dependent, and one of the things to consider is the age of the child, because when they're very young, they're going to assume anything their teacher says is normative. If the teacher says people of the same sex get married and their families are happy, they're going to think that, it's perfectly fine for people of the same sex to get married and have their families be happy. So perhaps the same ruling may not come out if the students are older. Frankly, I think they insist on a fact-dependent evaluation so that if progressives bring a parallel claim, they can say, well, we said it was fact-dependent and the facts here don't support a religious liberty exemption. But other than that, there really isn't a clear limiting principle, meaning if a parent doesn't want their child to hear about evolution because it's contrary to the religious beliefs about how the earth was created, they can argue that their child should not have to go to the section in biology about evolution. And if you have enough parents complaining about that, then the school might simply decide not to teach that unit anymore. There's so many things that people object to now. The one example that Justice Sotomayor also highlighted, what about all the religions that believe that men and women have very different roles in society, and in particular oppose women assuming positions of power? Are they going to object to learning about women in law and business and politics? Are they going to insist it undermines my religious view that my daughter's proper role is to marry and have children, to be exposed to all these female figures who defied God's law about her proper role? Are we just not going to talk about successful women in schools? Or at least are the schools going to have to notify parents every time they teach about women? Again, there is absolutely no limit to what a parent might object to on religious grounds. And under this ruling, they are now constitutionally guaranteed the right to pull their child out of that class.
We'll have to see how the ramifications of this decision play out. Thanks for joining me today, Caroline. That's Professor Caroline Mala Corbin of the University of Miami Law School. Coming up next, it's a groundbreaking decision in the world of animal law. A New York judge rules that dogs are part of the family. I'm June Grasso, and you're listening to Bloomberg.
Dogs have found their way into every corner of our lives.
Hey, Ed. Hi, baby. Hey, hi, Toulouse.
There are companions.
Your dog.
Our saviors.
Here, Lassie, take it to Grant.
Our pop culture icons.
Peter, you hear that?
And yet, we're only beginning to understand how their brains actually work.
The documentary Inside the Mind of a Dog was a hit on Netflix. No surprise, since about 65 million Americans have dogs as pets, well known for their loyalty and affection for the humans they bond with. And now a groundbreaking decision recognizes that emotional bond. A Brooklyn judge has ruled that dogs are no longer just property in the eyes of the law. They're members of the immediate family, something dog owners knew all along. Joining me is Christopher Berry, Executive Director of the Nonhuman Rights Project. Tell us about the case.
The plaintiff in the case was walking the family dog named Duke through a crosswalk in New York when a driver ran a stop sign, killing Duke, who died in front of her, while the plaintiff barely escaped injury herself. She was walking him on a leash as well, which was relevant to the judge's decision. And that was caught on security camera footage.
And historically, what's New York's law regarding recovering emotional distress damages for the loss of a dog?
So the traditional rule is that you cannot recover emotional damages for loss of property. You're limited to economic damages, which is usually just the market value, and that applies for all forms of property and has applied to companion animals as well historically.
So dogs are treated as property then?
Yes, companion animals are generally treated as property under the law in most ways, but binary categories don't necessarily describe things perfectly accurately, and that is especially true in the context of animal law and in particular with companion animals. People feel and treat companion animals as though they are members of the family and not just a piece of property that serves some utilitarian function. In addition to that, actually, we can look at animal cruelty laws as another example of ways that animals are distinguished from typical personal property. And so it's exactly those types of tensions that are adding up in the context of recovery for emotional distress in cases involving companion animals.
And treating Duke as property would mean that plaintiffs could only recover about $2,000 despite the fact that he'd been run down.
So one case that really crystallizes the problem of being limited only to economic damages for a companion animal was one from the Texas Supreme Court in around 2013 or so. It was Strickland v. Medlin. And what had happened there is a family dog had been euthanized by a shelter improperly. They actually had gone to recover the dog from the shelter and were told they had to come back. Later, when they came back, the dog had been euthanized. So they sued for, in Texas, it wasn't emotional damages, it was sentimental damages. And sentimental damages are available for special property like family heirlooms in Texas. And the court, unfortunately, adhered to the traditional rule, citing that 1800s case that in the case of dogs, you are limited to the economic damages, to the market value, and sentimental damages aren't available. But what was really interesting, and I thought inequitable about that decision is the Texas Supreme Court acknowledged an argument from the amicus in that case, on behalf of the animals that in a case involving the destruction of a taxidermied dog who happens to be a family heirloom, that sentimental damages would be available. And so I thought that in the most concrete way that I've seen in my 15 years or so of practice, just really quite clearly illustrated the problem and the tension in the law.
That's quite a contrast. In Duke's case, the plaintiff sued for negligent infliction of emotional distress. Tell us how the concept of zone of danger fits in.
Negligent infliction of emotional distress is a tort cause of action, and zone of danger is an important and traditional qualification to negligent infliction of emotional distress, which is that you have to have been within the zone of danger yourself, meaning that you almost suffered the injury that caused the emotional distress, and that a family member was the one who ultimately was injured and caused that emotional distress.
And what did the driver argue?
The attorneys for the driver said that this was just a, simple application of the traditional rule that you cannot recover emotional distress for destruction of personal property, and, didn't see it as being really any more complicated than that. The issue, of course, is that because this involved a dog, Duke, who was considered to be and treated like a member of the family, that binary sort of distinction of, animals must always be treated as personal property under all circumstances simply, I think, doesn't feel right. It doesn't fit well. It doesn't feel fair to consider him that way.
Why did the judge ask for outside groups to file papers?
The judge asked for amicus briefs in this case at the trial level, which is actually itself very unusual. And it seemed that the judge was really struggling with the rigid application of the traditional rule to the facts of this case, where you had a dog who was, treated as a family member. The judge had the video footage of the accident. The dog, Duke, had been a ring bearer for the family during a wedding. So under those circumstances, it seems quite at odds with justice, right, with fairness, with equity, with all the principles that we laud in the legal profession to rigidly apply the traditional rule that you're limited to economic damages in the loss of a companion animal.
It seems surprising to me, but maybe not to you, that a lot of big animal groups like the New York State Veterinary Medical Society, the American Kennel Club, wrote briefs siding with the driver rather than the family here.
Yeah, it's surprising. The veterinary community, often considered to be animal welfare groups. Fundamentally, though, these are professional trade organizations, and professional trade organizations are duty-bound, really, by the nature of their own organization to promote the professional interests of the practitioners, the veterinarians in this case, and not the animals. And their argument has been concerns that emotional damage recovery involving, deaths of companion animals through negligence will increase overhead for veterinary practices. Fundamentally, it's just about the dollars and cents for the profession.
So the judge here wrote, the court fails to see why a beloved companion pet could not be considered immediate family. Tell us how he came to that decision.
The judge recognized that he was between a rock and a hard place in this case, because you have the traditional rule that you're limited to economic damages, but then there's also the, fundamental principle of tort law that people should be compensated and made whole when they suffer damages. There's also instructions that, courts are duty-bound to do justice and to bring the law in accordance with present-day standards of wisdom and justice, in the words of the New York Court of Appeals. So recognizing that, the judge found that Duke could qualify as an immediate family member for purposes of the negligent infliction of emotional distress zone of danger claim. The headline is that Duke is included within an immediate family, but the subtext there were a lot of limitations to this holding as well. There were several factors that the judge cited that would limited the case. For example, that not only was she within the zone of danger, but she had Duke on a leash, right, which heightened the physical risk to her, and importantly, did not extend this theory to emotional distress claims beyond the zone of danger. There was a claim from another family member in the house who hadn't been present, but also suffered emotional distress, and the judge did not allow that emotional distress claim to go forward. So,
is this the first time a judge has found that a companion pet could be considered a member of the immediate family?
Yes, it is the first time that a judge considered a companion animal to be a member of the immediate family in the context of negligent infliction of emotional distress. And I include that qualification because one of the points that the Nonhuman Rights Project made in our amicus brief, and that the court recognized as well, is that companion animals do enjoy family status in other circumstances. In particular, when a divorce happens, there's a New York statute requiring courts to consider the best interest of the animal in awarding custody.
Yeah, I was surprised by that. I didn't realize that. Is there any indication the case is going to be appealed?
So this decision was a trial court decision. In New York, they can be published and cited. So, it's discoverable on Westlaw, and it'll have some persuasive authority just through the strength of its analysis. I wouldn't be surprised to see this case be appealed, particularly if there's no settlement, precisely because it is pushing the envelope in some ways.
It certainly seems to be. I remember the case that your organization filed to try to get Happy the elephant released from the Bronx Zoo, which didn't have a happy ending at the New York Court of Appeals. So if this case involving Duke is appealed, will the decision in Happy's case be relevant?
Well, there's some relationship between Happy's case and our claimant in that case and this determination of family membership, but there are some distinctions as well. So the overlap that I think is key is that courts, especially when they're applying their common law powers, need to really look at the law's animating purposes and not be beholden to artificial barriers. So there's a flexibility and a liveliness that is a part of the common law that we saw applied in this case regarding a dog being a member of the family, and that the Nonhuman Rights Project was arguing that the court should do on behalf of Happy. That's the similarity. And I'll note, too, in the same way that companion animals now are seen as members of the family by the vast majority of Americans, we also have modern science informing us that animals have actual liberty interests. They care about their liberty, and they suffer when those liberty interests are violated. And we have laws that say that we care about liberty. So there's certainly a connection there. The distinction, of course, is that, it's a companion animal family status in one case and an elephant's cognitive abilities and their liberty interest in another case, right? So there's certainly a distinction there.
Has the law in this area been evolving, or does the fact that we're talking about this case mean that it hasn't?
Yeah, there's sort of a paradox there, right? Because on the one hand, this is so limited, right? It's emotional distress, it's zone of danger, and the fact that Duke was on a leash was relevant to the decision as well. So there's something that's very limited and incremental. But really, that's the way the law works. And I think it's important to think about this sort of legal progress, not just as a snapshot in, one holding in one case, but to broaden our framework to be thinking about it as a trend over time. And in the case of the legal status of animals, the trend over time is unmistakable, that there's a positive trend arrow there. And we see that in this case and many others.
Well, it's encouraging to see that trend line. Thanks so much, Christopher. That's Christopher Berry, Executive Director of the Nonhuman Rights Project. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.